Robert was 74 years old. He lived in Columbus, Ohio. He had owned his home for 38 years. He bought it in 1986 for $94,000. When he passed away in the spring of 2023, that house was worth $410,000. His two daughters were the only people in the world he wanted to have it. They got it. Eventually. After 7 months of probate court. After $23,000 in legal fees. After a family dispute that nearly tore them apart because nothing was in writing, and both daughters remembered their father saying different things about who was supposed to get what. And after the youngest daughter sold her share to cover her own legal costs, the older daughter ended up with a house she had to refinance just to buy out the estate. What Robert needed was a revocable living trust. A local estate attorney in Columbus would have charged him between $1,500 and $2,500 to set one up. It would have taken 2 appointments and 1 afternoon of paperwork. The house would have transferred to his daughters in a matter of weeks. No probate, no legal fees, no court, no fight. Nobody ever told Robert that owning a home without a trust is one of the most expensive mistakes a parent can make. Nobody told him the house he spent 38 years paying for could spend 7 months trapped in a courthouse. Nobody told him the solution cost less than a used car. Robert is not unusual. He is the rule. Right now, across the United States, an estimated 60% of Americans do not have a will, and an even larger percentage have no trust, no beneficiary deed, and no plan for what happens to their home the moment they are no longer here. The median home value in this country has crossed $400,000. When a home that size goes through probate, the average family pays between $15,000 and $40,000 in combined court fees, attorney fees, and carrying costs before a single dollar reaches the people it was meant for. We are talking about hundreds of billions of dollars every single year draining out of family estates and into a legal system that was never designed to protect you. That is a college fund. That is a down payment for your grandchild. That is decades of equity dissolved. That is gone. This content is for educational purposes only. It is not legal advice, and it is not tax advice. Estate planning laws vary significantly by state, and your situation is unique. Always consult a licensed estate planning attorney before making decisions about your home or your assets. My name is Michael. Every week, I break down the tax rules, the financial traps, and the strategies that protect retirees from the things nobody else is explaining. If that sounds like something you need, hit the subscribe button right now and turn on notifications so you never miss a video. Today, I'm going to walk you through 5 things every homeowner over 60 needs to know about passing their home to their children. Number 1 is what probate actually costs and why your home is sitting inside it right now without you knowing. Number 2 is the difference between a will and a trust and why one of them does almost nothing to protect your home. Number 3 is the beneficiary deed, which is a 1-page document available in most states that transfers your home automatically with 0 probate and 0 attorneys required. Number 4 is the step-up in basis rule, which is a tax rule that could save your children $60,000 or more on capital gains the day they inherit your home. And number 5 is the estate planning change buried inside the tax legislation moving through Congress. Right now in 2026, that changes the math on everything, and if your plan was written before this year, it may already be outdated. Stay with me, because that last item is the one most families will miss entirely. The first thing you need to understand is what probate actually is and what it will cost your family. Probate is the legal process a court uses to validate your will, pay your debts, and transfer your assets after you die. It sounds orderly. It is not. In most states, probate is public, meaning anyone can look up your estate, your debts, your assets, and who you left everything to. It is slow, averaging 6 to 18 months for a home. And it is expensive. Probate fees are typically calculated as a percentage of your estate's gross value, not your equity. That means if your home is worth $400,000 and you still owe $80,000 on the mortgage, probate fees are often calculated on the full $400,000. In California, for example, the statutory attorney fee on a $400,000 estate is $13,000, and the executor receives the same amount, bringing the total to $26,000 before a single additional cost. In Ohio, where Robert lived, attorneys commonly charge hourly rates that accumulate to similar totals over a multi-month process. Add court filing fees, appraisal fees, and carrying costs on a vacant home, and a $400,000 house can easily cost a family $30,000 to $45,000 just to transfer. What do? Go to your state's official court website or search your state name plus the word probate to find your local rules and fee schedules. This will take you about 20 minutes and will show you exactly what your family is walking into right now if you do nothing. The second thing you need to understand is why a will alone is not enough to protect your home. Most people believe that having a will means their home will pass directly and cleanly to their children. Here's what actually happens. A will does not avoid probate. It goes through probate. A will is essentially a set of instructions for the court. It tells the judge what you wanted. The court then supervises the entire transfer process, which is exactly the months-long, fee-heavy process I just described. A will is better than nothing. It is not a solution. A revocable living trust is the solution. When you place your home inside a trust, you do not lose control of it while you are alive. You can still sell it, refinance it, or change the trust entirely. But when you pass away, the home transfers to your named beneficiaries immediately outside of probate without a single court appearance. The average cost to create a basic revocable living trust with an estate planning attorney is between $500 and $3,000 depending on your state and the complexity of your estate. That is a one-time cost that eliminates potentially $30,000 in probate expenses for your children. Let me put a dollar amount on it. On a $380,000 home, a trust that costs $2,000 to create saves an estimated $22,000 to $38,000 in probate costs. That is a 19-to-1 return on a single afternoon of paperwork. What do? Search the National Academy of Elder Law Attorneys at NALA, org to find a qualified estate planning attorney in your state. One consultation, usually free, 60 minutes. Let me stop here. Because item 3 is the piece of this video that I genuinely believe most homeowners have never heard of. And it is the most powerful tool for people who cannot afford or do not want to pay attorney fees right now. I am talking about a transfer on death deed, sometimes called a beneficiary deed or a TOD deed. Most retirees see a deed and assume it is a fixed document that cannot be changed without a lawyer and a title company. Here is what it actually means. A transfer on death deed is a legal document, usually 1 or 2 pages, that you record with your county recorder's office. It names a beneficiary, the person who inherits your home. While you are alive, it does nothing. You still own the home completely. You can sell it, mortgage it, or revoke the deed at any time for any reason. But the moment you pass away, ownership transfers automatically to the person named on the deed with no probate, no court, no attorney required. Let me put a dollar amount on it. On a $350,000 home, this one document, which costs between $15 and $50 to file at your county recorder's office, can save your family between $18,000 and $35,000 in probate costs. It is currently available in 31 states, including Colorado, Arizona, Texas, Nevada, Missouri, Ohio, and many others. What do? Search your state name plus transfer on death deed to find your state's specific form. In most states, it is available as a free PDF from the county recorder's website. You fill it out, $15 to $50. Yes, this is the thing nobody told Robert. The fourth thing every parent over 60 needs to understand is the step-up in basis rule. This is a tax rule that most families never think about until it is too late, and it could be worth more than $60,000 to your children. Here is how it works. When you buy a home for $100,000 and it grows to $400,000, your cost basis is $100,000. That means if you sold it today, you would owe capital gains tax on the $300,000 of growth. The long-term capital gains rate is 15% for most middle-income taxpayers, which means $45,000 owed to the IRS. But here's what happens when your children inherit the home instead of receiving it as a gift while you are alive. The cost basis gets stepped up to the fair market value on the date of your death. If the home is worth $400,000 when you pass away, your children's basis is $400,000. If they sell it immediately, they owe zero capital gains tax. Zero. None. That $45,000 disappears entirely because of the order in which the transfer happened. This is why giving your home to your children while you're still alive, which many parents do thinking they are being helpful, can be one of the most expensive gifts in history. A parent who gives a $400,000 home that they bought for $100,000 passes the original $100,000 basis to the child. If the child later sells, they owe taxes on $300,000 of gain. That is a $45,000 tax bill that never had to exist. What do? Do not gift your home, hold it, let it transfer at death, and consult a CPA or a state attorney to confirm the step-up rules for your specific state at AICPA.org or through a local CPA referral. The fifth thing, and the reason this video matters right now in 2026, is a change to the federal estate tax exemption that is directly connected to the tax legislation currently moving through Congress. The current federal estate tax exemption, which was temporarily doubled under the 2017 Tax Cuts and Jobs Act, is scheduled to revert at the end of 2025 unless Congress acts. The One Big Beautiful Bill currently being debated includes a provision to make the higher exemption permanent. If it passes, the exemption for a single person remains above $13 million. If it does not pass and the sunset occurs, the exemption drops to approximately $7 million per person. For most families, this does not trigger estate tax directly, but here's what it does affect. The planning strategies that wealthy families use to protect large estates, including irrevocable trusts, GRATs, and family limited partnerships, become far more valuable and urgent when the exemption drops. More importantly, for everyday homeowners, the state-level estate tax exemptions in states like Massachusetts, Oregon, and Washington start at $1 million or even $2 million, meaning a home plus retirement savings plus life insurance can push an ordinary retired couple into estate tax territory at the state level without them ever realizing it. Let me put a dollar amount on it. A Massachusetts couple with a $450,000 home, $600,000 in IRAs, and $200,000 in a savings account has a total estate of $1. 25 million Massachusetts taxes, estates above $2 million at rates up to 16%. They are approaching that line. A simple planning conversation this year, before year end, could restructure their assets and eliminate that exposure entirely. What do? Go to your state's Department of Revenue website and search estate tax threshold to find your state's specific number. Then book a consultation with an estate planning attorney before December 31st. Most offer a free first meeting. Now here is something nobody tells you. When you die without a proper estate plan for your home, your family does not just lose money, they lose time, energy, and often each other. The probate system was not designed to be punitive. It was designed for a world where most people died with far fewer assets and far simpler estates, but that world no longer exists. The average American homeowner over 65 has more than $250,000 in home equity alone. The system was never updated to reflect that. Courts are backlogged. Fees are percentage-based, meaning they grow every year as home values grow, and the government has never once sent you a letter saying, your home is probate exposed and here is how to fix it. The county recorder's office does not reach out. The IRS does not follow up. Your mortgage servicer does not mention it. The default outcome, the thing that happens if you do nothing, is that your family pays a price they were never warned about for a problem that had a simple, cheap solution the entire time. Take a married couple. Both are 68. They live in Phoenix, Arizona. They own their home outright. It is worth $420,000. They bought it in 1995 for $130,000. They have 2 adult children and 4 grandchildren. They have a will. They believe they are covered. When the husband passes away first, the wife inherits automatically because they own the home jointly with right of survivorship. No probate. Good so far. But when the wife passes away 3 years later, the house is now in her name alone. There is no trust. There is no transfer on death deed. The will goes through probate. It takes 11 months. Attorney fees and court costs total $27,000. The 2 children disagree about whether to sell immediately or hold the property. One hires a separate attorney. Total costs rise to $34,000. The home sells for $455,000. After all costs, the children split $421,000. Now meet the same couple. Same ages, same house, same will. But 3 years earlier, the wife spent one afternoon on Arizona's official transfer on death deed form, available free at the Maricopa County Recorder's website. She named both children as equal beneficiaries. She paid a $30 filing fee. When she passed, the deed transferred the home within 30 days. No probate, no attorneys, no family dispute. The children split the full $455,000. Same situation. 2 completely different outcomes. The only variable was a $30 filing fee and 1 afternoon of paperwork. The urgency here is tied to a specific moment. If the federal estate tax exemption sunsets at the end of 2025 as originally scheduled and Congress does not act, the planning window for families with estates between $7 million and $13 million closes overnight. But more relevant for most viewers, several states are actively reviewing their own estate tax thresholds in 2026, and home values in most major metros have pushed ordinary retired homeowners closer to state-level estate tax exposure than ever before. Oregon's threshold is $1 million. Washington State's is $2. $193 million. Massachusetts recently raised theirs to $2 million. A retiree in the suburbs of Boston or Portland with a paid-off home, an IRA, and a life insurance policy could be within $300,000 of an estate tax bill right now and not know it. Acting before December 31st of this year means your 2026 plan reflects the most current law. Waiting means your plan was built for a legal environment that no longer exists. Let me bring it all together. 5 things. Here they are in order. First, probate is real, it is expensive, and your home is sitting inside it right now if you have no trust or beneficiary deed. Go to your state court website and look up your local probate fee schedule today. Second, a will does not avoid probate. A revocable living trust does. Find an estate planning attorney at NALA.org for a free consultation. Third, a transfer on death deed transfers your home to your children with no probate, no attorneys, and a filing fee of $15 to $50. Search your state name plus transfer on death deed and file it before year end. Fourth, never gift your home to your children while you are alive. Hold it. Let them inherit it and receive the step-up in basis that eliminates capital gains tax entirely. Fifth, check your state's estate tax threshold right now at your state's Department of Revenue website, because home values may have pushed your estate into taxable territory without you realizing it. If this video helped you, hit the like button right now. It takes 1 second and it helps this video reach more retirees who need to hear it. If you are not subscribed yet, subscribe to the channel right now and turn on the bell notification so you do not miss the next video. And if you know a parent over 60 who owns a home, send them this video today, not tomorrow. Today. A quick text could save their children $30,000. Drop a comment below and tell me your situation. Do you have a trust? A will? Nothing yet? Do you know if your state offers a transfer on death deed? Tell me where you are in the process and whether any of this surprised you. I read every single one, and the most common situations become future videos. I will see you in the next one.